Morse VS Frederick. On January 24, 2002, students and staff of Juneau Douglas High School in Alaska were permitted to leave classes to watch the Olympic torch pass by. Joseph Frederick, who was late for school that day, joined some friends on the sidewalk across from the high school off-school grounds. Frederick and his friends waited for the television cameras so they could unfold a banner reading, "Born Hist for Jesus." Frederick was quoted as saying he'd first seen the phrase on a snowboard sticker. When they displayed the banner, then Principal Deborah Morse ran across the street and seized it. Principal Morse confiscated the banner and told Frederick to report to her office, where she suspended him for 10 days. Morse later explained that she told Frederick to take the banner down because she thought it encouraged illegal drug use, in violation of established school policy. Juneau School Board Policy No. 5820 states, "The board specifically prohibits any example of public expression that advocates the use of substances that are illegal to minors." In addition, Juneau School Board Policy No. 5850 subjects pupils who participate in approved social events and class trips to the same student conduct rules that apply during the regular school program. Frederick administratively appealed to his suspension to the superintendent, who denied his appeal but limited it to the time Frederick has already spent out of the school prior to his appeal to the superintendent. Frederick then appealed to the Juneau School Board, which upheld the suspension on March 19, 2002. Frederick then filed suit under, alleging that the school board and Morse had violated his Fifth Amendment rights. He sought declaratory and injunctive relief, unspecified compensatory damages, punitive damages, and attorney fees. Legal issue: whether a principal may, consistent with the First Amendment, restrict student speech at a school event when the speech is reasonably viewed as promoting illegal drug use. Opinion of Court by Chief Justice Roberts. Chief Justice Roberts, writing for a plurality of 4 justices, concluded that the school officials did not violate the First Amendment by confiscating the pro-drug banner and suspending the student responsible for it. After reciting the background in Part 1 of the opinion, in Part 2, he determined that school speech doctrine should apply because Frederick's speech occurred at a school event. Part 3 determined that the speech was reasonably viewed as promoting illegal drug use. And Part 4 inquired whether a principal may legally restrict that speech, concluded that she could, under the 3 exceeding First Amendment school speech precedents, other constitutional jurisprudence relating to school and schools important, indeed perhaps compelling interest, in deterring drug use by students. First, Robert determined that the court should analyze Frederick's speech under the comparatively strict doctrine of school speech, rejecting at the outset Frederick's contention that the case should instead be considered under the ordinary free jurisprudence. Roberts reiterated the circumstances, then explained, "Under these circumstances, we agreed with the superintendent that Frederick cannot stand in the midst of his fellow students during school hours at a school-sanctioned activity and claim he is not at school." Second, Roberts cited Bethel School District No. 403 versus Fraser. The jurisprudence of Fraser is controversial, but Roberts declined to apply it or resolve the disputed holding of that case. "We need to resolve this debate to decide this case." Instead, he explained that for present purposes, It is a nod to distill from Fraser two basic principles: that the constitutional rights of students in public school are not automatically coextensive with the rights of adults in other settings, that the substantial disruption analysis prescribed by thinking is not absolute. Third, Roberts cited the most recent student speech case, Hazelwood School District versus School Mayor. In that case, the court permitted a school to exercise editorial control over the style and content of student speech in school-sponsored expressive activities, declining to publish articles in the school paper that the public might reasonably perceive to bear the imprimatur of the school, so long as their actions are reasonably related to legitimate pedagogical concerns. Robert found that this case, though factually distinct, was nevertheless instructive because it confers both principles cited above. The history of public education suggests that the First Amendment, as originally understood, does not protect student speech in public schools. He praised Hugo Blas' dissenting opinion on Thinker and called it prophetic. Thomas cited the doctrine of in loco parentis, meaning in place of the parent, in his opinion. He traced the story of public education in America back to his colonial roots. According to Thomas, because originally public schools were intended to substitute for private tutors, public schools could discipline students as they like and had a far stronger hand in what happened in the classroom. In short, he continues, in the early public schools, teachers thought and students listened. Teachers commanded and students obeyed. He opines that because parents entrusted the care of their students to teachers, teachers have a right to act in the place of parents during school hours. Therefore, teachers should be able to discipline students if necessary. Thomas Lambasted, thinker for usurping the local school district as a traditional authority of the judiciary. Thomas believed that Frederick was neither spigot givers not openly advocating drug use, but granting such an impertinent constitutional protection, will be surrender control to the American public school system to public school students. On the other hand, Justice Alito, with whom Justin Kennedy joins, wrote a concurrence indicating that he agreed with the majority opinion to the extent that it goes no further than to hold that a public school may restrict speech that a reasonable observer will interpret as advocating illegal drug use, and it provides no support for any restriction of speech that can plausibly be interpreted as commenting on any political or social issue, including speech on issues such as the wisdom of the war on drugs or legalizing marijuana for medical issues. Alito agreed that Morse did not violate Frederick's First Amendment rights and emphasized in his concurrence that the holding only applies to students who advocate illegal drug use. He opposed the educational mission and in loco parentis analysis in favor as a special characteristic of schools that he identifies to be ensuring the physical safety of the students. Alito concluded that an exception must be made to the First Amendment free speech guarantee to protect the students, since, according to Alito, advocating illegal drug use possibly lead to violence. But Alito insisted that this small reduction of what is protected by the First Amendment is at the far reaches of what the First Amendment permits. Justice Stephen Breyer concurred in the judgment in part and dissent in part. arguing that the court should not have directly answered the First Amendment question in the case, but rather decided based on a qualified immunity. Qualified immunity is an affirmative defense that requires court to enter judgment in favor of a government employee accused of violating individual rights unless the employee conduct violate clearly established statutory of constitutional rights of which a reasonable person would have known. Because it was not clear whether the school principal's actions in taking down the banner violated the First Amendment, Breyer would have simply issued a narrow decision indicating that she was shielded by qualified immunity and gone no further. Justice Stevens, with one Justice Souter and Justice Ginsburg joined dissenting. The justice argued that the court does serious violence to the First Amendment in upholding, indeed lauding, a school decision to punish Frederick for expressing a view with which it disagreed. Stevens wrote, "The school interest is protecting its students from exposure to speech reasonably regarded as promoting illegal drug use. Cannot justify disciplining Frederick for his attempt to make an ambiguous statement to a television audience simply because it contained an oblique reference to drugs. The First Amendment defends more, indeed much more."